Okay, good morning, everyone. Today's episode, we're in episode number 7.
I don't know.
Number 7, I think.
7, 8.
We've been off the podcast for a little while. We're trying to get back on, and what better way to get back on by having a wonderful guest, Bita Di Lisi from Stonegate Legal Services. She is a paralegal and specializes in landlord-tenant issues. All right?
You are.
Yeah.
Good morning.
Good morning. So maybe you want to expand on that, what you do, how long you've been doing it, how you got here, and go ahead.
All right. Well, my career actually started in real estate. I'm going to age myself, going back to 2004, 2005, when I started acquiring landlord and investor clients who purchased small to medium-sized apartment buildings and commercial plazas, but they weren't in the country or in the province to deal with the day-to-day operations. So just like my real estate counterparts, I offered to manage their properties. And I actually ended up at the Landlord and Tenant Board on a lot of their matters, like non-payment of rent, late payment of rent, cash for keys. And 9 times out of 10, my matters were getting dismissed because I was not a licensed paralegal or a lawyer. So I went back to school. I obtained my paralegal license to add a service to my investor clients. And then my business shifted. And unfortunately, I don't sell real estate anymore. I haven't done so for almost 10 years. Our team, which we're a team of 7 paralegals, we provide legal support to realtors, landlords, and investors throughout the province of Ontario, only in the realm of landlord and tenant matters.
Okay.
Beautiful.
Long explanation.
So we've since we've known you, we've sent you a few clients, and I can tell you they've been happy,
Yeah.
very happy so far.
Great.
I realize now you do a lot of the inboarding, and then you do a lot of the inboarding, and then you'll distribute it to your
Yeah, so
team.
like I mentioned, when they're calling us or when they're calling our team for support, it's not a very happy call. They're already frustrated. They're probably stressed out. They're probably out of pocket tens of thousands of dollars. So we're not a happy call to make, but we provide legal support to them, and we help them get rid of their headache.
Yeah.
What was the point where you shifted from, because to go for to leave real estate, which can be, if you're, I'm assuming based on how you operate now, you had a successful real estate career as well. What made you shift it? What was that shifting point to this where you said, okay, I'm not going to do real estate anymore. I'm going to do litigation basically for tenant matters.
So I was being approached by managers, brokers, being asked to provide training sessions for their realtors. And in doing so, it's kind of like prospecting for me, is, educating the realtors. And in doing so, I wasn't able to, my real estate business started suffering a little bit. And it wasn't fair to my clients. So I decided to let go of buying and selling for my clients and dive deep into providing legal support.
Gotcha.
One thing as realtors, we get caught sometimes because we actually give more advice than we should sometimes. It's out of our realm, really. It's not out of our realm. We're not qualified to speak to some things, right? And more often now that I've met, I say, listen, this is a great contact. I may say a few things that I know, but however, whatever I'm telling you, just verify and speak to so-and-so. I never realized, especially in the last few years, I never realized the importance of having a good paralegal on your team, just like you would a real estate person, a real estate lawyer, a doctor, et cetera. You need your arsenal of people. And it was sort of overlooked, at least for me, of having, especially if you're in the investment world, having a paralegal that specializes in land, and very important that they specialize in landlord-tenant issues. Not that, we do it.
And they fight traffic tickets too, right?
Yeah, exactly. It's just like us, you may be licensed to do it, just like us. Although we do commercial deals, we'd like to say we do them, no problem, but we're on the lower scale of those commercial deals, only because, there's
things you got to know.
There's things you got to know, especially when you get to higher levels, bigger numbers, and even though we're licensed to do it, we can't say that we're doing it, and it'll be a disservice to offer that or say, I I can sell you that,
Industrial building
industrial.
or
Well,
yeah.
maybe it depends on the size, but again, if it's big enough, let's be realistic. We're not the right people to.
Not just that too. The people, when you're in that world, you have a network of people that you will engage with, and to find deals, to whatever it is. And we wouldn't have that unless it's like you said, lower end. If it's retail, street level office, that kind of stuff we do. But beyond that, you want to have the right people in the right place.
Yeah, absolutely. I mean, there are many paralegal firms, I would say, or many solo paralegals that just focus on doing 2 or 3 different types of laws. We only focus on one, and we are swamped. We have a team of 7 paralegals, all focusing on one area of law. So it's hard to be a jack of all trades and to specialize in one. So we're not a jack of all trades. We know landlord and tenant law because we are landlords ourselves. We have a background in real estate, and that's how we're able to provide support to our real estate agents and investors.
So, just getting to the basics, landlords and tenants are governed by.
The Residential Tenancies Act. That is the piece of legislation that governs landlords and tenants. Now, the Landlord and Tenant Board it's kind of like a court-like setting. That is where disputes are handled. So both landlords and tenants can apply to the board if they're having an issue with one another. The board will then hold a hearing, and they will determine the outcome of that problem or of that issue.
So the Residential Tenants Act, and I've seen it often, I had to look it up, or otherwise known as RTA.
Yes.
How often does that change? How often does that legislation change? How often do you have to be updated with that? I know it's pretty extensive as it is, and I'm just curious how often do things change for you?
So amendments are made to the acts every few years.
Okay.
And we provide training on these amendments to real estate brokerages, just to keep you guys as agents, who I say you guys are the frontline workers of the landlord and tenant industry, because your clients reach out to you first before they reach out to us.
Right.
So the act is amended from time to time. But I do have to say that there was a podcast that I was watching a few days ago and on Instagram. I'm not going to name that podcast, but there were agents that were bashing the Residential Tenancies Act. And I couldn't wrap my head around why they're bashing it. Have they read it? They're saying that the laws are all for the tenants. And I just want to provide clarity. Can I provide clarity on whether or not the laws are...
I'll be honest, I
you would
thought
think
the same
that
was
yeah.
lopsided.
Yeah,
I get
so
it.
let's talk about that. So maybe the people on that podcast can watch this
Yeah,
one and be up
Let
to,
us know who
to
it is
date, right? After
We'll send it to them
that's
after.
right. We'll send it to them. So the Residential Tenancies Act is the law, okay?
Yeah.
The law. The Landlord and Tenant Board is the court-like setting where disputes are handled. The law the law provides a balance for both landlords and tenants. You will never find anywhere in the law, in the act, that says, hey, tenant, stop paying the rent. Or, hey, landlord, don't do any maintenance or repairs. You will not find that. There's nothing in the law. No member of the board will order that. It doesn't exist. Here's the problem, okay, when people say that the laws are all for the tenant. The problem is not the law. The problem is that landlords are often victims of a broken system. Mm-hmm. Because, for example, let's say 5 years ago you were to come to me and say, Steve is not paying rent. How do we get him out? We would serve notice, file with the Landlord and Tenant Board. We'd be in front of the board in about 60 days. We'd probably get an eviction order in 90 days. We'd have him out in 120 days.
It's the time it takes now, right?
It's exactly. So here's what I mean by a broken system and landlords being victim to it. Right now, if you were to come to me and say he's not paying rent, we would serve notice. We would file with the Landlord and Tenant Board. Then we play the waiting game, 7 to 8 months to get to the board, hoping that our matter is heard. Just because you have a notice of hearing doesn't mean your matter is going to be heard. Now, the board will make a determination as to whether or not Steve should be evicted or whether or not Steve should commit to a repayment plan. And if they rule the repayment plan option for Steve, if there's a breach, then and only then can the landlord apply in accordance to Section 78 of the Residential Tenancies Act, which is breach of an order, and file for eviction. That entire process can be a 10 to 12 month process.
Which
Which is ridiculous.
which indirectly looks as though we are serving the tenant, as there's an imbalance, we feel,
That's
right? We're stuck
exactly
with no
it.
payments, and it looks that everything is to the favor of the tenant because now he has about a year to just
And I
don't
get
wanna-
Live for
wanna say
free.
sit around.
I get
but-
that. So it's not the law. When we say, oh, the laws
the-
are off,
it's the system that's
when
broken.
you're a licensed realtor, you are a professional. Do you agree? When you're talking to the public, they're relying on your words. They're relying on what you're saying, and they dive off of that.
Right.
So as a licensed realtor, when you're going on social media and you're saying, well, the laws are all for the tenant, and you are a big agent, that says a lot. So it's not the law that's
Are you saying the system though?
it's the system.
The system is
It's the system. So we got to be mindful of what we tell the public. It's the system that's
That is-
broken.
okay. When you say broken though, the system is what leans toward the tenant.
Well, I don't think it's that it's leaning. She's saying it's just broken, and
It's-
then the fallout is it favors the tenant.
That's
Oh,
right.
no,
That's
right?
where that comes
It does-
from.
yeah,
It
that's right.
favors the tenant, but it doesn't favor the tenant.
Just
it's a
inadvertently.
government process. Any government process, if you've had an experience of following a government process or going through one, you know that there are lengthy delays. Now, as landlords, whether you're a small landlord or a big landlord, you have to treat real estate ownership for the purpose of income, rental income, as a business. You can't just, rent out a place and say, well, I'll rely on that income to pay the expenses. Because all it takes is for that tenant to fall behind 1, 2, 3, 4, 5 payments, and that's it.
Yeah,
Right?
yeah.
You're relying on a system. And you need to make sure you have deeper pockets so that in the event that something happens, you can carry the property
Because of the system.
because of this. So it's not the law, it's the system.
So, oh, sorry.
No,
go
no. I
on.
was going to say. So, how, in your opinion, how would they? What is the best way to fix that system? I'm assuming it's going to be hiring more people. I'm sure there's not enough people to get the job done, which is typically the case in government.
So let's talk about
But we
that.
also have so many government. I don't. Anyways, yeah.
Any government process is a long process. The province has actually injected $6.5 million into the tribunals. The Landlord and Tenant Board is a tribunal.
Yeah.
And what they've done is that they've actually hired a whole batch of adjudicators. So remember when I said it's a business? The Landlord and Tenant Board is a business. What happens when you hire new employees?
You gotta
No
train,
different than McDonald's, right? When McDonald's hires new employees, they have to train them.
So the fruits is gonna be a while to see the
Exactly.
fruits.
Exactly.
Are
We're
we
not
seeing
there
any,
yet.
Are we seeing any fruits since the I guess was there a peak?
It's
into the-
getting better, I have to say. Now you're looking at about 6 to 7 months instead of 7 to 8 months for a notice of hearing.
Okay.
Now that may not sound like it's getting better, but in the grand scheme of things, if you look back to 2020 when the board had incurred 80,000 applications and they were taking months, 7 to 8 months to get through them, now it's taking 6 to 7 months. It's getting better.
Sure, it's better, but I don't think it should be expected month at a time, right? It's almost like because unless they hired gradually, did they hire gradually, or did they actually put a?
No, I think they hired a whole batch.
So at
of
some point, it should be a
adjudicators.
huge drop. It should be, once that clearing of training
The
has happened,
backlog.
the backlog is going to shrink back to
It should.
3. It should, right?
It should.
Otherwise, there was a waste somewhere.
That's right. That's
And
right.
we're gonna see
but
that
it's
too.
not just. So here's the thing. It's not just hiring employees. It's to better their systems and their process. So one thing I'll tell you, the Landlord and Tenant Board that we're experiencing, as everybody knows, all hearings are online. If you were a party to a hearing, you would log on online. There'd be a moderator who takes your attendance, and then depending on whether your matter is contested or uncontested, you get sent to the hearing room, where you meet with one adjudicator. Now there are multiple hearing rooms on the same hearing block. So now you have hearing room A with this adjudicator and hearing room B with this adjudicator. So they're widening up their hearing blocks, and they're including more adjudicators to hear more matters at the same block.
It makes sense. They don't need the space to accommodate.
That's right. Everything's
But
online now.
You would have thought that because that peak in volume kind of happened probably when it started to move towards online, right? Because I would think prior to 2020, all those cases were not seeing, they were seeing in person, right? So wouldn't the fact that they went online helped, like or at least streamline and save
It
some
should
time?
even be less than what he's
Yeah.
saying. It should be, aside from the additional people, more adjudicators. More adjudicators should equal, the reduction, and maybe even better. If we know it's working, we just add a few more to shorten it even more.
Right, and that would make sense. But think about it. Think about you're used to technology. You have your phones, you log in, you know how to use it. Think about the low-income tenant. Think about the tenant who doesn't have the means or the internet access.
Yeah. You need the
Right? So you need someone who has a smartphone
Right.
or who has a computer or a laptop
Or
who
elderly.
has internet, who's able to put in the hearing room address.
Right.
There's many tenants that are asking for in-person hearings because they don't have access to smartphones, access to computers, access to internet. The board is holding, even though everything is online, tenants can request for accommodations to have their matters heard in person.
Again, that's
Again,
system
another
is
delay.
broken, is leaning toward
That's
the tenant. Well, this is the perception for these reasons. But as far as the system being broken, I understand when you're looking at the Residential Tenants Act, it's balanced and is meant to be balanced. But do you think the adjudicators that are existing now, is that broken as well as in terms of decisions? Are they always kind of leaning toward the benefit of?
They gotta lean. They have to work towards the law, right? They can't.
No, they will,
Right.
but the laws also can be sort of tilted
Gray.
how
Right.
you see it. So is there evidence of that being broken? The decisions based on the law that should be balanced, and the decisions, are you seeing an imbalance there?
Okay, so an adjudicator, the role of the adjudicator is that they are an impartial party, right? They are not supposed to be on one party's side.
Right.
However, at the end of the day, we're all people. When you have a matter, if I tell you, oh, this guy's not paying rent, he owes $50,000, your perception of him, you already make up your mind as to what you're going to decide prior to even listening to what he has to say, right? That's the role of an adjudicator, is to make a decision when they hear one side and another side by applying the law.
Right.
Again, at the end of the day, we're people. And whether or not that adjudicator is biased, maybe they're a landlord, maybe they're a tenant, maybe
Right.
they're, I don't know, their parents were evicted, maybe they struggled to pay rent at one point in their lives, maybe they own property that they rented to a tenant that owed them money, right? You're not always going to get an adjudicator who's 100% impartial.
Because right away, it looks as though the landlord has all the power. There's an imbalance of power.
Just
Optically,
naturally,
to
yeah.
me, naturally. So naturally, adjudicator would give all the cushions available to the tenant, I would think, because right away there's an imbalance of power, or it feels like that.
It feels like it sometimes.
So in order to be sure,
Yeah.
I'm being honest, now I'm just thinking as
Yeah.
adjudicator, in order to be sure that there is an even playing field, I'm going to give the tenant everything in my arsenal to be sure that there isn't an imbalance. You know what I mean? And
Yeah.
like just naturally, it would, to me, that creates a broken system in itself. But-
Again, broken system.
Yeah.
Especially if that tenant attends a hearing with no representation, right? Think of it, you're going
Yeah,
to a
then they're
hearing.
Oh, right.
even more vulnerable, right?
That's right. That's right. But remember, adjudicators have to work within the law, right?
Yeah,
So you
it always
just-
has to fall back on.
That's right.
It
on the
does.
Residential
The
Tenants
law
Act.
And I'm
says.
sure he's not adding things for the tenant. He's using everything in the arsenal. I mean, everything in the law to make sure he's that's what. So, I was coming to. Oh, I lost the train of thought. Make sure you skip this part. What was I? No, what was I thinking about the imbalance? Oh, sorry. When there's no representation on the landlord side, they're not very sympathetic or empathetic. I don't know what the word. They're not very empathetic to the landlord. Like they actually go harder on them, I would think, without that representation. Whereas if a tenant went in by himself, oh, that's okay.
They'd be more
So
sympathetic.
that's not really true.
No? Okay.
No, because remember, impartial party, they have to preserve the rights of both the landlord and tenant. Sometimes there are landlords who attend the hearing with no representation, let's say a non-payment of rent, but they don't update the board on the amount of the arrears. So when you're going to a matter that, the tenant owes money, non-payment of rent, you have to inform the board 5 to 7 days before of all of the rents paid or outstanding from the date that the application was filed. Now, some landlords, if you don't have representation, you don't know that you have to do that. It's a process of the board. Most adjudicators, 9 times out of 10, they will allow the landlord to provide that evidence on the spot.
Which is
So,
not- yeah,
which
which-
is great, because the only alternative to that is to say, landlord, we're going to reschedule this, wait 4, 5, 6 more months, and then submit the update sheet at the next hearing. So there are certain instances where a cushion is provided to a landlord, but depending on if you are that landlord or if you know that landlord, you may or may not feel that the adjudicator is making the right
And it-
decision.
No, go ahead.
No, in fairness, he had no business of going by himself.
I was
He
going to say,
didn't know
that's
that.
a perfect example of why you need to hire a
right.
professional to.
That's
So this is
right.
very important.
Like, right?
No, I can do this. I can do that. No, you cannot. Even if you think you do,
Yeah.
just
Yeah,
get somebody
just
who's qualified. Even just by perception for the adjudicator,
Yeah.
it means something.
Absolutely.
That
So-
that leads,
Absolutely.
so when a tenant files or a landlord files to go to the board for whatever reason, for whatever issue, let's say there was a non-payment of rent and you have to submit whatever N11 or whatever you're gonna. We're not, us as realtors are not supposed to actually fill in that form for the landlord or the tenant, correct?
As realtors, you should not.
Should not,
Yeah.
correct?
I stopped
Now-
doing that, by the way.
Good.
Yeah, yeah. So we should not. Now, what's the reason? Like, I know the reason for that, but you tell us the reason, because
Oh,
a lot of
yeah.
now landlord themselves can do it. If I'm
No,
right,
landlords
they
can.
they can.
Can.
But why should we not? And why should maybe even the landlord make sure that a paralegal is doing that for them?
Well, the landlord should have a legal representative do it for them so that they don't make a mistake. Mistakes are costly, not only money-wise,
Time-wise,
time-wise, which is sometimes more important than the actual dollar value.
Like, I've heard the tiniest mistake
Yes.
can cause, they'll just throw it out and you
They
have to
won't
resubmit.
even hear the matter.
Right.
That will be a 2-minute hearing and thrown out. You have to start all over again.
Like the date was in the wrong spot or
That's
something
right.
like that.
Or
right.
you forgot to sign, or you forgot to put basement apartment 1, or whatever
Right.
the case is. But realtors should not serve or draft or fill it out and have their clients sign any legal document. Number one, they're not licensed to do so. Okay? Only licensees should be doing it. And when I say licensees, licensed under the Law Society of Ontario. Okay? Number two, they don't know the requirements or consequences that are attached to that notice. Number three, well, your errors and omissions insurance doesn't cover you. So guess what? If you do it on behalf of a client or for a client, if it gets to the board and it gets thrown out, imagine that client is owed $35,000 and it's thrown out because the realtor did it. That client can come after you. You will then contact your errors and omissions insurance. Errors and omissions insurance will say, guess what, Steve? You're not covered. Good luck.
And we had
you're
all
on your own."
we had all good intentions, obviously. Anybody can easily
Exactly.
backfire, right?
Exactly. Number four, you're opening up yourselves to liability, personal liability. And number five, you're opening up your brokerage to liability.
Okay, so realtors do not fill in
Should
or
not.
sign or
Yes.
sorry, do not serve any notice.
Yeah, don't serve it. Don't draft it for your clients to sign it.
Right.
I even have realtors who ask me, can we just download it and send it as a blank copy to the client? No,
Not even.
because
Really?
you're providing a service.
So we can't even send them the copy of the N11.
You
as a-
shouldn't.
Okay.
The N11,
I've sent a
Yeah.
link to the website.
send a link to the website, because the
Yeah.
website, I mean, they can look at 100
Right.
forms, right?
Oh yeah, because I guess if you send them the wrong form, as an example, then
Yeah.
that's
We
They're-
text
they're
them.
real-
We text them your number now.
Oh, or you can do that.
So
so. So let's get into some of the nitty gritty stuff. So what are the most common legal issues you see with tenants and landlords?
So the biggest one right now is that landlords or realtors will call us and they'll say, we're trying to sell a property and this tenant is not providing access. Or we're trying to sell a property and this tenant won't allow for videos or photos. Or we're trying to sell a property and we're trying to get this guy out so we can list it so we don't have any issues with access or vacant possession. What do we do? And as always, I provide them with their options and then I make a recommendation. So the first option in the case of a potential sale of a property is to list the property with the tenant as it is. Okay?
Yeah.
You have to be courteous to the tenant. Hopefully they allow you to market the property. List it with the tenant. Depending on the buyer's intention, whether they want to move in, whether they want to assume the tenant, or whether they want vacant possession, then and only then can an N12 notice to end the tenancy for the landlord or new purchaser's own use is to be served. And their second option is cash for keys. Cash for keys is not extortion. It's a legal and mutual agreement to end the tenancy. And I recommend that this be done prior to listing the property for sale.
Right.
Cash for keys should be facilitated by a legal representative, not realtor, not property manager, a legal representative who's well versed with the law and the strategy. These two go hand in hand.
So so a realtor should not.
Make up the contract for sure.
No, but not
No.
even
Don't even attempt it.
attempt to.
It's
okay.
not the same as selling a property. And I'll tell you why. A legal representative will contact the tenant and bring the parties together so that there is a meeting of the minds. The realtor,
One-sided.
they want to sell it, right? That's their interest in the property. They want to sell it, move on to the next property. The legal representative will bring the landlord and tenant together. Once there's a meeting of the minds, they will draft settlement terms and the N11. Settlement terms are like the rules of the game. Who plays what role, who holds the money, when are keys exchanged, if there are any other terms. And the most important thing in a settlement term agreement is a full and final release. And what that is that the parties are mutually agreeing to dissolve the tenancy and releasing one another from future liability.
That's the N11.
That's the settlement terms.
Okay.
The N11, so the settlement terms accompany the N11. The N11 is an agreement to vacate. Okay? There's no settlement terms, an agreement to vacate. It says that if the parties mutually agree to end the tenancy on such and such date, if the tenant vacates and leaves any belongings behind, the landlord can discard. It also says to the parties that if the landlord files with the Landlord and Tenant Board, they can pursue an eviction. However, here's the thing with the N11 that many landlords or realtors don't know. That once the N11 is signed, it's filed with the board with the terms of settlement. The board will then issue an ex parte order, which is just a simple eviction order or a fancy term for an eviction order without a hearing.
Yeah.
Now, here's the catch. Tenants have 10 days from the date that order was issued in order to file a motion with the board or the courts. And a motion is basically you're asking the board or the courts to do something. In this case, you're asking them to put a hold or stay on an eviction.
Even though everything was in place.
You got it. So the N11 doesn't provide 100% protection.
Where's the balance on the other side? Where's the balance in the RT on the other side?
Well, remember, the law doesn't owe anyone anything. You only owe two things: the right to be heard and a right to a fair hearing. Whether or not you get a fair hearing, it's another conversation. But those are the only two rights that both parties have. So if a tenant files a motion to stay the eviction, meaning that N11 order is not enforceable until that stay is lifted by a board member. So the board will then hold a hearing, usually 1 or 2 months thereafter, and either allow the tenant to continue their tenancy or lift the stay. So in instances where realtors get involved, going back to the agents, oftentimes when agents get involved and they try to coerce or persuade the tenant to sign, that's when the issue happens, because then the tenant will file a motion, get in front of the board, be able to prove or advocate their position at the board that the realtor got involved, and they were coerced into signing.
What if it was just a landlord and the tenant who did the cash for keys between themselves?
Well, that depends on what's in the cash for keys. What was drafted.
Isn't it up to them? Because
It
there's
is.
no-
It is. But sometimes, depending on what you put down in writing and depending on who interprets that, it can change the meaning of that clause or that term.
Would you say that if it's anybody but a paralegal or a lawyer, what you're saying is is more likely that the tenant is going to question it and therefore put the brakes on it, because they can still do the motion even if you facilitated everything, correct?
That's right.
But it's probably unlikely, maybe, because it just felt better.
Yeah.
You
I
were
mean,
dealing with one professional, and instead of the realtor having a bias in their eyes,
Right.
the landlord having a bias in their eyes. So, so I hear you what you're saying. So, but my question, let's say the 10 days. So what you're saying is, even if that was all signed, as a realtor, wait 10 days. Don't list it yet. You're probably you might have to take it off if there's a motion, I guess.
wait till the tenant's out. Never mind the 10 days.
Oh,
Never mind the 10 days
Oh,
because there could be exceptions. Tenant could be in the hospital for 10 days or 2 weeks and didn't receive the order. If they're able to prove that they're in the hospital, the board will allow for that exception.
Oh, okay.
So wait till that tenant is
Or
out.
can't you just get confirmation from the tenant they received it?
You can, but
because the cash
if the tenant is informed, if they got free legal advice, which they're entitled to,
Mm-hmm.
they will be told of what they can and can't do.
So, okay. Oh, so you're saying wait till they get out to be
Wait
sure.
till they're out. Be sure.
Let's say, let's say we didn't do that, and the 10 days elapsed. It's a firm thing, unless say there was no hospital, etc. But at closing,
He's still there.
they're still there. Is it a whole new?
Once you have that order,
Yeah.
there's a termination date. The N11 termination date is already in that order that you would have filed as soon as the N11 is signed.
Right.
The sheriff you can file with the sheriff, or the landlord can file with the sheriff as soon as the day after the termination date in that order.
Great.
File for eviction.
Perfect. Now, when you do that, and you have every right, how soon can that sheriff come now?
We're seeing 3 to 6 weeks. It was 4 to 8 weeks, and then for Toronto, it was about 3 months. It's getting better. The sheriff is getting better.
Okay, that's good. So of a just because I'm staying, it'll take 3.
Call it a month. A month and a
30
bit.
days.
But what happens if that whole thing creates a whole slew of issues? Like the buyer.
It's a
has
domino effect.
It's the domino effect. The
Yeah.
buyer that bought the place, he's out. He doesn't have anywhere to go. He's going to have some damages, etc. Can we go after? I mean, can we go after the tenant in that case, or?
So if a tenant signs an agreement to vacate, okay, an
Yeah.
agreement, the N11, and they don't leave, and the property is sold, and the seller incurs costs,
Both, yeah.
the
Yeah,
seller
seller.
can go after a tenant.
But-
But if the N12, which is a notice, is served, no N11 is signed, and the tenant doesn't vacate,
Yeah, then it's not as easy.
then the seller cannot, or the seller landlord cannot go after a tenant. See, that you have to distinguish between the N12, which is a notice, and the N11, which is an agreement to vacate.
I'm
Okay?
referring to the agreement.
The agreement to vacate. Okay, in that agreement to vacate, a landlord or seller can go after a tenant if they interfere and don't vacate.
Right.
Here's the problem. Here, I don't want to say problem or catch. If the tenant doesn't have any assets,
Yeah, that's the
Yeah.
thing.
if they're not working,
Yeah.
Yeah.
This is another
what are
thing.
you going after?
Exactly.
Right.
So this is another thing. So you could win a case. Yeah, you could win, but then you have to collect the money.
And forget about the collecting the money. Then you have to go through the hassle and the time and the cost to go and sue them.
Right.
Exactly.
Right.
So it's about, if they're not about the damage, you could win, no problem. But then the other side is you got to
Then
get the money.
Right.
So this
But
is
if they
why.
own assets, you should pursue depending on
Right.
how much you're owed.
Right.
But
Yeah,
no
I mean, this
assets.
is inside stuff that you just gotta. You just said it, okay? Make sure that let's have them out to be
Yes.
sure.
Best way is cash for keys.
Cash for keys.
Get them out. Even wait till they're out.
Wait till they're out. List that
But
property.
if you have the N11 signed and they've agreed, and then it's fairly safe You have you at least have recourse.
You have recourse, but nothing
zero
is
assets,
100%.
But yeah.
Exactly.
Make sure they have a car and some other
It's-
stuff before you.
it's- It
send me an
sounds
letter.
good.
I mean, you also said it before that even if they have, you still have to incur costs
Yeah,
to
and time and-
collect.
Yeah,
right?
it's not pretty. So it's I mean, you're
No, a
you're-
lot of time if you vetted the tenant and or the tenant and the landlord have a good relationship and they have a good feeling about it. It's you've seen where landlords have said it's fine, the tenant's good, we're good, and hopefully it works out well.
Hopefully.
But hopefully.
I mean, cash for keys is a great alternative to having to wait to get to the board,
Right.
right? And I'll tell you, last year we did about 947 cash for keys, just cash for keys. Two of the tenants,
when did cash for keys become? I know it's a thing, but when did it become? Was it always a thing?
it was always a thing.
Except
just
now
a
it's just
fun
more
term.
prevalent now. Pardon?
It's just a fun term, cash for
Right.
keys. Cash for keys is a settlement. People
Right.
make settlements all the time. It's not extortion.
What do you typically see as the going rate for cash for keys?
There is no going rate.
yeah.
There is
I
no.
know.
But
what
to
do you see?
justify-
What do you see? What like in terms of
An
do you
offering.
see 2 months, 4 months? What do you normally see?
So I'll tell you, to justify an offering, what do you have to do to get the tenant to leave? You need to provide them with first month's rents, last month's rent, money for moving costs, incidentals.
Right.
So first and last month's rent now, market rent. So usually market rent times 3 is justifiable. Justifiable.
just so you're starting.
Starting.
Justifiable. What's-
Justifiable. Yeah, I mean, I'm able to justify $10,000 to you as a cash for keys offering,
Plus moving costs.
plus including moving costs. So if the
Including or
average,
plus?
including,
Including.
if for example, if I were to offer you $10,000, the average rent right now is what, $2,500.
$2,500.
Okay, so $2,500 to $3,000 times 3 is about $9,000. $10,000 looks better. They may
Right.
incur some costs, give them some McDonald's money, whatever the case is. Usually gets it done.
Okay.
But tenants can come back and really say, well, no, I want 15,000.
Right.
I want 20,000. Right?
Just as a nice cushion.
Just-
that
yeah.
times 2, I guess, would be not that you want to overspend, but sometimes it's worth it. If you have I'm not saying you would have if you have a property that's $2 million, and instead of paying 9, you're paying 18, maybe it's okay. Like,
Yeah, I mean, and other factors play a role too. If you're at a height of a really hot market,
Yeah,
you
you
want
want
to
Right?
capture it.
You
You
wanna-
you don't want to wait you don't want to wait to like, you don't want to miss the fall market, for
That's right.
example. The
Right.
next market is going to be historically the spring again.
That's
You
right.
don't want to, so you want to capture that. So there's a price to pay. It's a business.
it's a business.
It's a business. It's not, it probably makes sense. It could make sense to pay 3 times the amount. I'm not suggesting anything, but again, it's a
too,
business case.
Depending on the position that landlord's in, if they have to sell.
That's
if they
right.
have- right?
I was just going to say, depending on the landlord's position, we've had landlords not pay a cent and just provide the tenant with 4 to 5 months. Sometimes it's not about the dollar. Sometimes the tenant wants
Just time.
time.
Yeah.
Sometimes they
Right.
want their child to finish school in the same
Yeah.
area. Sometimes it is about the dollars. Sometimes they want 100,000. Sometimes they want 150,000. Sometimes they want 20,000. Sometimes they're good with 5 to 7,000. Sometimes they're even good with you waiving the arrears that they owe in order for them to walk away in 30 days. So and when I say the cash for key strategy should be facilitated by a legal representative who's well versed with the law and the strategy, that legal representative will be able to provide you with a strategy that suits your circumstance.
Right.
If I can, what's the best way to vet tenants or qualified tenants? I can say with certainty, as far as the credit scores go, which is something that we ask for, Equifax, a credit score, and a report. We can verify that report through our system here. We can just cross-check, and that just eliminates any kind of potential fraudulent documents. But past that, what other tools could somebody use, or is there apps out there?
So there are the traditional tools like the credit check, like the letter of employment or income verification, pay stubs. And then there are the newer tools. So I'll give you 2 tools that all realtors, landlords should be looking into. There are 2 websites. One is openroom.ca. The second one is canley.org. Okay, openroom.ca is a fantastic website, and what that is it was born from a landlord who experienced difficulties with their tenant. So what they did is they opened up openroom.ca, allowing any landlord in the province of Ontario to publicly upload landlord and tenant board orders to openroom.ca.
This is objective.
Great.
Landlord-Tenant Board documents.
Orders.
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 Orders only. So that means that
So it's a legal public document anyways.
exactly. That means you can go on openroom.ca, put in, for example, a keyword search. You're vetting a tenant, Bita Di Lisi. Press enter. Any order that contains those keywords will pop up. Is that not a great tool for you
Yep.
to look at and consider, well, if she owes $20,000, why am I mean, everything else looks great, but she owes this landlord $20,000.
What happened, right?
What
Yeah.
happened? Right? I'm not going to say, come on in, here are the keys.
Yeah.
Right? The second website, canley.org, is not a public website. It's the court system and the tribunals uploading landlord and tenant board orders. This is just going back to 2020. So I would use that as a secondary tool, but openroom.ca should be used by everyone. It's a
Everyone.
fantastic tool.
Would you use would one if you're using the first one, do you actually need the second one?
Yes, because sometimes landlords don't upload their orders.
I see.
So you're on there anyways. It takes a minute to do a search. Same keyword search.
Oh, sorry. So this is a volunteer kind of thing for landlords to upload?
So most
like-
landlords probably don't even know.
Right.
That,
But
right.
right now there's something like 15 to 18,000 orders uploaded.
No, that's great. But at the same time, one, as Antony said, that they're not aware of them, of that site. And two, even if they are aware of it, I got to upload. I'm not doing it. Like it takes time, I guess. I don't
Yeah.
know.
It
And it
does.
takes a know-how. You got to be somewhat technologically savvy, I guess. And then three, you know what? I had trouble. Let my competition have trouble too. I don't know.
Yeah, but I get it, but some landlords really don't want it to happen to somebody else.
Right. So it's more like if I
I have
give, I
something
hope
to
to
prove.
get back.
That's
Yeah,
right. That's
got
right.
it.
Everybody should be using it. I use it personally. I use it in my business. My team uses it when we're vetting or using it for evidence. It's a great tool.
So that,
Great
and
tool.
then, so those two sites.
Those two
Those
sites.
two sites you're getting a pretty robust
it's
check,
free.
right? Yeah, and
It's free.
Oh, that's
yeah.
great too, yeah.
It's free. It's great.
There's no membership or.
It's robust. I would think that there wouldn't be as many people uploading that.
And
yet,
it's newer,
yeah.
right? It's
newer,
only
that's
a few
why,
years
yeah.
old.
Yeah.
Yeah.
But then the second part would be there.
What do you mean?
Sorry, like if it wasn't uploaded, as you said, the second part would catch it.
The second website.
The second website.
It may.
Again, that's the court uploading
Landlord and tenant board orders going back to 2020.
2020. Okay.
But nothing
in
before.
May. Got it. In
May.
May. That's what you mean by in May.
Yeah.
If it
But
was
going
20
forward now, from
Yeah.
2020 on, it will have it there.
It will have it there.
Okay.
Yeah. Lots of orders there.
Is there a lag between the order done and uploaded? Do you know? I'm s-
Well, on Canley, there could be. I
Yeah.
don't know what the lag is. I'm assuming it's somebody's job to do it. But on Open Room, it's up to the landlord.
Yeah, open room is. I get
Yeah,
that. I'm
it's up
just
to the
wondering if
landlord.
there was a lag. Like, I didn't even see that. Like,
Yeah. And if you do your keyword search properly, it should pop up.
And is it pretty user friendly in the second site?
Yeah, absolutely.
Okay.
Both of them are.
Yeah, so that's great to know. And you did mention it last time. I think I did go to one of the sites once. Nothing came up, but it's a great thing. So that, and like you said, even when you dot your I's, cross all your T's, you could have something happen, or you could all of a sudden have a tenant that unfortunately lost their job or et
Yes.
cetera. But
Is there anything else though? Is there anything else beyond what we do and that we can do? There's also social media, mind you. What we'll do is we'll
Social
go on
media is
social media
great.
and we'll look at, make sure their LinkedIn lines up with what we see on employment letters. Make sure that on social media they kind of seem to be who they are. You can even kind of see what kind of person they are from social media, right?
Absolutely. So social media, I kind of put into the traditional, just because it's
Right.
been around for so long. People should be doing that
Right,
anyways,
right.
right? But yeah, definitely agree with you. Social
Yeah.
media, you want to make sure that their online life is in line with what you have in front of you.
You should even Google map. Like we've had occasions where the place of employment that they put, it was like
Doesn't match.
it was a empty parking lot that was being developed by a
Yeah.
builder. Like so, and it was definitely, we found out after, it was definitely a fraudulent application, because the website, when you went onto the website, if you dug deep enough, you'd see coding, and it was showing up coding, and it was so.
Yeah. Lots of fraud.
There's definitely a lot of fraud. Yeah.
Yeah.
I have one big question, and I say this often, and I hope I've been saying it correctly. I tell people there's a big correlation between a good credit score. I mean, anything could happen in credit. You could have a little blip. There could be a story behind bad credit. However, generally speaking, there is a correlation between good credit and a good, responsible paying tenant. Would you say yes? Okay.
Yes, and I'll tell you personally, I like to meet my prospect. I like to meet them, and I go off of my feeling. It doesn't matter what the paperwork says, what their letter of employment says. I need to see that person. I need to go off of my feeling. I've been in circumstances or situations where that vibe is completely off. Something about that person just doesn't sit
And you
right.
should trust it, right? People
That's
should
right.
trust it.
That's
Like,
right.
there's one thing about paper, and I totally agree. When you actually meet them even through a Zoom, it's fine.
Right.
In person is probably better, but even through a Zoom, you do get the vibe that you should trust. So whatever.
So I go off of my feeling.
right.
Right? I
Yeah.
mean, I've had tenants who meet me at the property or my own property, and they explain why, and then they're able to provide me with confirmation of what they're telling me, and everything just jives.
Right.
And I give my rental unit to them, and I've never had a problem with them. Then I have other tenants where I meet them, and I'm like, that something doesn't sit right.
Right.
Doesn't.
This is important.
Yeah.
This is
Yeah.
very
Very
important.
important. Yeah.
Intuition, trust it.
Yeah.
We have a client that
Absolutely.
always meets with the land before she rents it out. She always wants to meet with them
Always.
all the time.
Always.
I've been not really heavy on meeting necessarily. It's just not top of mind. Everything looks good, but more and more now, because I'm recognizing the value of it.
Yeah.
I'm actually bringing out hey, listen, let's do that Zoom. No, it's okay. No, let's do it.
Yeah.
It takes 20 minutes.
Yeah.
Yeah.
It's probably more, just as equal value or
Right.
weight to these documents. So.
That's right. Or you know what else you can do? I've done in the past. I've held open houses where prospects can just walk in. I get to meet them. My husband gets to meet them. I get to see what they're dressed in. I get to see what they drive, how clean their shoes are,
How clean
if
their
they
car is.
have
Do you check
dirt under their nails. Sometimes I
Right.
pop in and I look at their car. Remember the
You
way
would
they,
never get me as a tenant if you saw my
the way they treat their car is how they're going to treat your rental unit.
Right.
I mean that you're in a confined space. If it's a disaster.
likely, yeah.
Yeah. But it's
Right.
a combination of everything. It's not just the
Yeah,
employment letter
one
or
thing, yeah.
just the credit score.
All right. So we're just going to wrap it up because this went longer than we thought, but it was great information. Thank you so much for joining us. I know we actually had to redo this because our first shot, our sound kind of went.
You know what I realized? We can go on for hours.
Yeah, yeah.
Like there's so much. We want to have you on again.
Then you wonder
Absolutely.
I wonder why Joe Rogan's podcasts go for like 4 hours sometimes. You just keep going, right?
No.
But anyways, let everyone know where they can reach you.
So you can head over to stonegatelegalservices.ca. Lots of great information there. Our contact information is there. If you are a landlord or a realtor and you're looking for a consultation for yourself or your client, you can book a free discovery call or a consultation right off of the website.
Perfect.
Thank you, Bita.
Thank you.
Thanks, guys.